recording so that I don't miss that opportunity.
Okay.
Well, yeah, I've got 9:02 on my computer, but if you would like to get things rolling.
All right. Sure. Okay, so I'm gonna filling in for Peter Danforth today as he is out in the woods on the Appalachian Trail. So good for Peter. Hope he's having a good time. But yeah, so Megan Rodier with the Lamoille County Planning Commission and the new vice chair of the Lamoille BOIC. So I'm going to fill in today for Peter. So we'll call the meeting to order. I actually see, oh, now I see 9:02 on my screen as well. So why don't we just do the typical round of introductions first? I know a lot of us know each other, but there might be some folks who are less familiar with everyone. So why don't I just call folks off? I already introduced myself, so I'm just going to call folks off, and if you could please introduce yourself and where you're from and whether you're a voting member or not on the Lamoille Basin Water Quality Council. So how about we start with Cliff?
Jenkins, Northwest Regional Planning Commission.
Good. Dan?
Dan Kahneman, Winooski Conservation District out of Montpelier, and I'm an alternate, and since Mel is here, I'm definitely an alternate today.
Become a recurring part of European reality.
Mel?
The purpose is to stress
Somebody has the radio on the background.
Yeah, there's a little bit of background noise. So if you're not currently speaking, if you can mute yourself, please. Okay, thanks. That's better. Mel, do you want to go next?
Hi, I'm Mel. I use she, her pronouns. I'm with the Franklin County NRCD, alternate.
Ken.
Ken Mink, Georgia Conservation Commission, a voting member.
Excellent. Thanks, Ken. Lauren, you're next.
Lauren Weston, district manager for the Franklin County NRCD, she, her. And I think I'm still the voting member.
You are.
Okay. I know we've been doing some rearranging, so thank you.
Good. Thanks, Lauren. Lorna.
Hi, I'm Lorna. I'm the water quality intern for NRPC.
And Joanne.
I'm Joanne Kanowski from the Stewards of the Greensboro Watersheds, and I'm the alternate for Chris Steele, who couldn't make it today.
Okay, great. Thank you. And then Brent.
Sheets. Brent Sheets, Town of Fairfax Director of Public Works, and yes, I'm a voting member.
Excellent. And I see, looks like Karen's on the phone.
This is Erin. Can you all hear me?
Oh, Erin, you're on the phone, yes?
Yes, hi. This is Erin DeReese from Vermont River Conservancy, and I am a voting member. And I am on my way to Pennsylvania, like hopping in the car right now, so I'm going to be listening, but you will not see me.
All right.
Just wanted to let you know.
Safe travels, Erin.
Thanks.
Let's see. Did we get everybody? I saw initially Brent Raymond hop on. Did he?
Brent Raymond's out of Morristown. I do not believe I'm a voting member.
Excellent. Thanks, Brent. And I think that's everyone.
Well,
Dean.
I'm Brad Holden. I'm the town administrator of Underhill, and I'm here representing Chittenden County Regional Planning.
Excellent. Thank you, Brad.
Yeah.
And I'm Richard Goff. I'm alternate for Megan.
Thank you, Richard. Sorry, it's like I can only see so many people at once. All right, thank you. Did we miss anybody? I just want to make sure we didn't miss anyone.
I'm Dean, I'm staff, but most of you know that. And just to recap, I will say that Lorna, who introduced herself as the water quality intern at NRC. She will be doing the minutes today. So I have, counting towards the quorum, Lauren, Megan, Ken, Brad, Aaron, Brent, and Joanne is filling in for Chris. Richard's here, but he doesn't need to count. And Dan, Kenneman, and Mel are both here, and they don't need to count because of the representation that we have. Oh, I'm sorry. Well, actually, one of them can count for Peter, but we're plenty over the clearance bar for quorum.
So it looks like next is the meeting protocols.
Yes.
So why don't we just recap those real quick? I don't know if you want to screen share those again. Dean, I also have them up in front of me. So again, just during the meeting, you know, we all want to be respectful of each other. So introduce yourself. We did that. As possible, public members should have their name in Zoom and title, and whether you're a voting or alternate member of the council. And should have your camera on as possible. Appreciate that. Members are expected to stay focused and on task. Try not to multitask too much. And then use the raise hand function, please, if you could, when you want to speak. And otherwise, you know, stay on mute so there's not a lot of background noise. All members will stay, yep, I already mentioned that, will stay on mute. And then any comments made in the chat, Chris staff, such as Dean or Lorna, can read them out loud so that we can all hear them. And okay, so next on the agenda is, are there any conflicts of interest that anyone needs to declare today?
As there are no applications, I don't think that's likely, but for anybody who's new here, we have this agenda item because it's a time for people whose applications would be reviewed to make it clear to everybody that they will not be voting on their own application.
Okay, great. So if there's no conflicts, and I can't see everyone, so feel free to, yeah, if there's anybody there, Dean, feel free to call them out. So the next thing would be, are there any adjustments to the agenda today? Okay. So why don't we, if there are any adjustments proposed to the agenda, why don't we move on and do approval of the meeting minutes from the July meeting?
I make a motion that we approve the meeting minutes of the July meeting.
Okay.
For Lorna's benefit, who was that? I'm sorry, I didn't quite hear.
Brent Sheets. I made
sorry,
sorry,
Brent.
Brent
Sorry.
Sheets. Thank you, Brent. And yeah, when folks, if you're making a motion or seconding, if you could just call your name out too for the meeting minutes, that'd be helpful. So Brent Sheets has made a motion to approve the meeting minutes from July. And do we have a second?
I'll second. This is Joanne Hanowski.
Okay, thank you, Joanne. Joanne has seconded the motion. Does anybody need to abstain?
Brad Holden, I'll abstain.
Okay, Brad Holden is abstaining.
I'll similarly abstain. I wasn't there.
Okay, and Lauren is abstaining. Okay, so we have Brad Holden and Lauren Weston has abstained. Any discussion? Richard, I see your hand up. Oh, can you come off mute?
I approve.
I'm listed as quorum, and you were there, so I can't be quorum. I'm alternate.
Good catch.
Okay, the minutes for today's meeting will note that correction.
Okay. Thank you, Richard. Pointing that out. Okay, so any further discussion on the motion for the meeting minutes? Let's scroll through here. I don't see any. Okay, so all in favor of approving the July meeting minutes for the Lamoille work, say aye.
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 Okay. Any opposed? Nope. Okay, the motion carried. All right, so let's see what's up next on our agenda. Got multiple screens here.
Megan?
Yes, Dean.
Yeah, pardon my interruption, but I just wanted to clarify one thing. Karen's iPhone, is that Karen Bates? I don't know. Did we get a...
Yes, based on what she said in the chat.
Okay, sorry, I didn't
Okay.
see that. Thank you.
Yeah. I thought that was Karen.
Okay,
Bates.
thanks. Thanks very
Okay,
much.
so yes, so it's Karen Bates on her iPhone. Okay, so yeah, so meeting minutes are approved. Any public comment, other than what we have on the agenda today? Any public comments that folks would like to bring up? No, I'm not hearing any. Just gonna scroll through and make sure I'm not missing any hands. Okay. So if there's no public comments, then okay, so the next thing on our agenda, which we started to mention, is it's the seating of members, and so Chris Steele is going to be replacing Christine Armstrong as one of the watershed organization representatives for the Lamoille Basin Water Quality Council. And so it's my understanding that Chris Steele is also affiliated with the Stewards of Greensboro Watersheds. And then Dean, do we need to take a formal vote?
No.
That change? No. Okay. I wasn't sure. But Chris was unable to join us today, correct?
Yes,
But
that's correct.
thankfully, Joanna is, and thank you, Joanna.
Okay. And Joanna, did you want to say anything else in regards to that?
I can just say that Chris will be an engaged member of the council. He's been a member of the Stewards of the Greensboro Watersheds for 4 or 5 years. He's on the Greensboro Association board, and he also is the chair of the Greensboro Conservation Commission and is involved with Orleans County OCR and CD. So he's well connected and will be a great representative, and I will be on as the alternate.
Excellent. Well, great. We look forward to having Chris join us, and so maybe next time Chris will join us, and yeah, sounds like Chris will be an excellent addition to the councils. Thank you. Okay, so yes, thanks for your screen sharing, Dean. So next is a report on budget adjustments, and we didn't have any, correct?
That's correct.
Okay, so we didn't receive any requests for budget adjustments. So we can move on then. So the next main thing on the agenda item was bonding. And Dean, I know you wanted to talk a little bit about the opportunity for bonding for the implementation of projects and the construction phase.
Yeah, thank you, Megan. I guess I would see it as less of an opportunity than an obligation, a requirement that comes into play for some projects, not a lot of projects, but when it does come up, I don't want it to be a surprise to anyone or their contractors. And so it seemed like a worthwhile topic to do a mini training on, essentially. I have a few slides, so I'm just going to quickly go through those, and hopefully if people have questions, I'll be able to answer them. I have had some experience with bonds working in the transportation realm, but they're a little bit different in the clean water service provider world. But anyway, learning as we go along. So the rules that were written after the law was passed that established clean water service provider system, those rules indicate that you have to have bonds when project costs reach a certain level. And there have to be two types of bonds. One is called a performance bond, and one is called a payment bond. And the performance bond is something that ensures that the contractor completes the project as has been agreed in a contract. And the payment bond is there to make sure that any subcontractors and suppliers get paid by the contractor. It's essentially insurance. It protects the owner of the project. So for example, if people weren't paid and then if a subcontractor needed to get their money and was looking around for places to get that money, the owner would be protected by the bond. And there are also things that provide confidence that the project will be done as is intended. I mentioned a minute ago that bonds are required at a certain level or certain cost of a project. And bonds are required, both of those types of bonds are required when the value of the project at the implementation stage is over $500,000. And that might seem like, a cost that wouldn't be encountered very often. But for some of the projects that I've sort of in the WISP and BWIC pipeline, they're major projects that could easily reach that level. The guidance that has been adopted as part of this effort also encourages the use of bonds for the performance of the project when the cost is lower at $250,000. But at this time, the clean water service provider doesn't have any interest in establishing a requirement for a level below the one that is set at 500,000. I would be interested in hearing if anybody thinks it would be worth the QUISP's consideration, but I'm not sure that that would be the case. And I also just want to mention, as long as I'm throwing around numbers, that neither of the numbers for these thresholds lines up with the number that's used with site access easements, which is $200,000. So the numbers can be a little bit confusing at times because they don't line up. So who's part of the bond? The bond participants are the contractor, the company that is providing the bond, the surety, and the owner. And we're going to talk about that, or I'm going to talk about that in a second. The vehicle for the bonds is a form that the clean water service provider has adapted. We've had an attorney review them, and they've been tailored to the QUISP and BWIC process. So the bonds make clear who the parties are: the principal, the contractor, the bonding company, and the owner, the clean water service provider. You'll note that the parties to the bond don't include the organization that's actually managing the project. And I'll editorialize a bit a little bit later about that. So hopefully this graphic that I've got on the screen now can help explain things a little bit. We have a flow of money for QuIS projects that starts at the top or at the beginning from the state of Vermont. Money goes to the Regional Planning Commission, which is also the QuISP essentially. Money gets passed through the QuISP to a sub-grantee. So after the basin councils have said, yep, we recommend funding for a project, that could be a box off to the side, but the funding flows from the clean water service provider to the sub-grantee. And when we're at an implementation project, the sub-grantee has a contract with a contractor and the dollars flow to them. One of the things I have to make clear with the way that the bonding system is set up is that it essentially pulls out the role of the sub-grantee. The owner, the Regional Planning Commission, has this relationship with the contractor and the bond issuer, but what I would call the agent, in a sense, the sub-grantee is acting like an agent through some of this, but they're not involved in the bond. And whether or not that's something that should be considered in the future, I'd be willing to have conversations with people about. But I just want it to be fairly understood that the parties of the bond in the bond are the owner, the contractor, and the bond issuer. And I realize that the terminology, the owner, could seem a little bit weird. Sometimes owner is also equal to developer. And I am not using the word developer because in many respects, the sub-grantee is the developer of the project. But I'm preferring to call them the agent because I don't want there to be any confusion. So what happens when a bond is in place? Let's say the contractor defaults. Well, then the insurer, the surety steps in and they provide the money to get it done if somehow the money's been lost, or they find a replacement contractor. And they also make sure that if subs aren't paid, they get paid through the payment bond. The thing I want to say is that the way that the sub-grantees, the folks like the conservation districts and everybody else who would receive a task award to do a project, they're setting up their contracts normally in ways that aren't putting too much money at risk. You know, no one's signing a $1 million project with a contractor and paying it for it up front. So there's not a lot of money that's at risk. So it may seem like using a missile to kill a mouse to protect the financial interests, but this is just in general how things work. So some of you may work with contractors who have limited experience with bonds. A lot of contractors already have extensive experience with bonds, but in very quick terms, that they work through a company that is in business to do this. They are typically paying a percentage fee, which in order to buy the insurance, basically it's 1 to 3% of the cost of the project or of the contract that they have. And something that's really important to note is that bonding cost itself is an eligible cost in the project. So the project requirement for a bond comes along with the recognition that it needs to be included. So if you have a $500,000 project, then the 1% fee will be added onto that in terms of the costs of the project. It's recognized. And these things are governed by Vermont law. There are forms that were developed by the Clean Water Service Provider, by the Regional Planning Commission, like I said. And one of the reasons why we did that is there are some there are some other sources of forms. The American Institute of Architects has one. There's a body or board of engineers that have them, but they charge for the use of those forms on a per use basis. And so by having our own forms, we're not requiring someone to have to buy those forms. They identify the core parties, they have key information, they have a definition, and then they have, and there are two forms. So in the payment bond, it does the things that you can see on the slide. I'm not sure, I'm not seeing hands either if there are questions, because I've been going at this for a while. But basically, if the clean water service provider got a claim from someone, we would notify the surety and the contractor that we've received this, and then the surety, the insurer, must defend and hold the QUISP harmless. So basically, they carry the water for us. But if there's been some glitch and the contractor ends up paying a bill that someone had lodged a complaint about, then the problem goes away. Essentially, there's no obligation. In the performance bonds, there's language that guarantees the faithful performance by the contractor. And again, these documents have notice requirements. They're procedural. They talk about having notice, a conference, a determination that there's formal default, and then there's the surety arranging for the work to be completed and paid for. I've said a lot in a little bit of time, and so maybe I should just stop and see if there were any questions before I go any further. Maybe that's not the case, and if not, then
Lauren has a question.
Okay, sorry. Hi, Lauren.
Hi, Dean. I don't want to jump the gun in case you are planning to talk about a little bit more about this, but I know, I guess just in terms of the bonds, it's my understanding that the contractor would need a bond for the whole cost of the project, even if the QUISP is not paying for the whole project.
Yeah, that was a funny thing. So even if you have $1 million project and the QUISP investment in it is $300,000, then we've been told that the bond covers the whole amount.
Okay. And then I'm just gonna probably echo what Dan is saying. Like, who is in charge of doing all this paperwork? It was me last time, and I know it didn't go the smoothest. So I'm just wondering if there's maybe a different plan moving forward.
Yeah, so this is one of the things that I was referring to when I said that I think that some adjustments in this could be considered, because the parties of the bond are kind of one step removed. The fact that that there's a layer in between the owner, the QUISP, and the contractor, which is usually in the form of the subgrantee, an organization like yours, it kind of makes sense procedurally, since you're doing all of the contracting with the contractor, that the bonding be part of your package, let's say. But that's not the way things were set up, because so essentially it could be as simple as, you have the forms and we've provided them to you, and you give them to the contractor, and if they have questions, they could talk to us or they could talk to you, but they have a relationship with you, so it's consuming your time if they have questions. Whoops. And if what you're wondering is like, it's taking a lot of time to answer those questions, and like you didn't budget for it, and maybe I should stop there to see, is that essentially the issue?
I think that's part of the issue, is like who should budget for it. and like who really needs to understand the bonds? Like, this training is great. But like, yeah, like I can't answer questions about a bond.
Yeah. And I guess I would say is that given the way things are set up currently, you are not obligated to explain them. It's not something that would be on you. And, you know, if we could rewind the clock in the case of the project that you've had some experience with, it might be that the contractor has direct communications with us. But from the standpoint of the subgrantee, the way things are right now, you should hand over the forms. The contractor should have the contractor fill them out, and you should supply them to us. But that's oversimplifying things a little bit, because like in the case of the first go round with your project, the contractor listed your organization as the owner. And so time was lost essentially catching that glitch. So it's, I think, one of those things where if you hand over the paperwork and you give it to the contractor to have them execute, I mean, we, I believe, have a version of the forms that are pre-filled out with the owner as the QUISP. So as long as they're using that version of the form, there shouldn't be a mistake of putting in the organization as the owner, which is what had happened the first time. So we learned that we need to make sure that the forms that are given to the contractor already specify that the owner is the QUISP.
And then I guess I'm just curious why myself as the subgrantee wouldn't also need these bonds with you if at the end of the day, like, the contractor could say, hey, Lauren, you didn't pay me, and they want to lodge a complaint against me to you. Like, why don't I need a bond?
Well, I think that an organization could. I mean, I think this could result in a lot of questions being raised with DEC if it becomes a common practice for the subgrantees to have bond requirements. But I don't think anything would stop you. But then that would just raise the question of redundancy. But I mean, some redundancy may be unavoidable, but I guess I can't really comment on whether or not your organization should have your own. I just want to avoid a situation where it's like overly redundant, which is why I'm saying that, you know, maybe there is something, an adjustment that can be made where there is a bond agreement between the QUISP and the contractor that's somehow assignable to the subgrantee, so that it puts you like in the middle of it. So it's like it's a setup for the QUISP, but then as a practical matter, it's between the subgrantee and the contractor. I mean, that might be a way of having it set up, but it wasn't something that we explored when the system was set up.
Gotcha. Then I guess like to that point, I would be curious if you could send the language from the law that establishes this, because in my mind, if these are all reimbursement-based grants, which they are, this all feels counterproductive. And if we're saying, okay, you still have to do it, even if it's a reimbursement-based grant, I really don't understand why the subgrantee wouldn't also need one.
Yeah, well, that's the fact that these things are reimbursed is where there is already financial protection. So it does seem like whoever was in the room when this concept was developed may not have appreciated that it was like a bit of overkill. Somebody might have said it's belt and suspenders, but it's it does make you wonder, like how much is it really going to be a problem? Was it a solution in search of a problem? And I see Ken's hand up.
Hi, Dean. Yes. So I'm assuming this would just come in the implication phase of the project.
Oh,
And
yeah.
so the project goes out to bid, you receive 3 bids. Let's just say, for example, they're all over 250,000. So you select a bid, but then do you have to go back to the QUISP to add in the surety piece?
So what hopefully will happen is that in the presentation of the budget, when the WIC is reviewing it, it's a comprehensive enough budget that people have thought ahead. And I know that this budgeting stuff is not easy, and it's not easy even when, like, let's continue to use Lauren's project as an example. It's a major project, and the QUISP and the BWIC funded the final design, and so she's working extensively with an engineer, and the QUISP and the BWIC also approve implementation, and that same engineer is playing a very extensive role, and they have come up with an estimate of the probable costs. So Lauren comes to the WIC with a budget that hopefully is going to be adequate. Now, something that may need to be, given a little bit more attention when the engineers are putting together the budgets is, oh yeah, got to remember the bond costs. But we hope that it isn't going to be so close that that slight little change for the bond is going to mean coming back. Now, if you remember, the BWIC already has policies that say minor adjustments in cost don't have to come back to the BWIC. So up to 10% costs are a relatively simple, and now I think there's a cap. I forget the details of the policies, but minor adjustments can occur without going back to the BWIC, so that if it is in fact a minor adjustment, there isn't going to be a loss of time. But it is only implementation. And so what you're pointing to, Ken, is that, if someone's costs come in just below the amount of the task award, or right at the task award, if there's an additional cost, then there is going to have to be some amendment to the task award. And the way that happens is, if it's a small adjustment, it can be done administratively. But if it's a big adjustment, and that all goes to the heart of, like, trying to come up with a reasonable budget when you come in and request support from the Basin Council. And it's an art as much as it is a science. Does that answer your question?
I think so, yes.
Lauren, did you have a follow-up question?
Yeah, I guess, Dina, have we gotten any clarity on when change orders happen during implementation? Like, how does that relate to the bond? I know we kind of went through a process, but I don't know if that'll be the same process moving forward.
Yeah, so we learned with Lauren's project that the bonds have a feature in them that basically means that if change orders are issued for a project, you don't need to run back to the bonding agency to get them to adjust the coverage. The coverage is issued with the understanding that there can be change orders and increases in the budget. So that's something we learned when I was out, but that's some of what I think you're asking, Lauren, and it would be good for everybody to know that there can be change orders without having to adjust the bond. But if what you're also asking is like, how much does the QUISP need to know about your change orders, then that's an area that is coming into focus more and more. But in the big picture, you have a task award for a certain amount. If you were lucky and you had a contractor who submitted a proposal that was $100,000 less than your maximum award, you've got that $100,000 to play with, without having. But the QUISP in the task award is saying we want to know about changes, and so it would be that there's no surprises. But ultimately, it's the subgrantee that is the one who's managing the contractor. And what I want to avoid is the QIS becoming a surrogate or a second manager of the contractor. So, in your recent project, or in that project, we want to know, and we've had a meeting with someone in our office who's done a lot of these types of projects, and she's offering her opinion and advice on how you might manage your project, but it's still your project to manage. So, I mean, we may develop rules of thumb where if your change order is going to modify the contract by more than 10 or 15%, then the QIS may say, "Are you sure?" But we're not saying that now, but I mean, that's part of what the communication is about. It's like, have you asked your contractor this? Have you asked your contractor that? Just to exercise good practice. But I mean, is the heart of what you're getting at, though, how much does the QIS need to be involved in a change order? I think for many things, we don't need to be involved, but it's good for us to know so that when the invoice comes in, we don't see all these change orders and we go, what the heck happened to that project?
I think there's two questions I'm probably asking, and one is, I guess in this experience, did you learn that all performance and payment bonds automatically adjust, or just the one that my contractor happened to have?
It's a
And
okay, it's a function of the form.
the function of the form. Okay, so the form that we're using has that built in.
Yeah, that
Okay.
it's a function of that form.
But so I guess then, if the contractor's asking for a $30,000 change order, are they really then asking for a budget adjustment of, is that 30,300, so that they can then pay their 1 to 3% on the bond? But then it's kind of like a cyclical tomfoolery, if you get what I'm saying.
Yeah, okay. I get what you're saying, because I think some of this is all going to be reconciled at the end as these costs, well, it's reimbursable, right? So where's the invoice that shows the charge for that slight increase in the bond coverage? Did we lose Lauren?
No, I'm still here.
Oh, okay. Sorry. You moved on the screen.
Sorry.
Yeah. So I guess what you're asking is like, when is the contractor going to give you the invoice for that additional amount? I mean, if they were not, if they didn't give you an invoice, it's nothing to process. But if they're really on the ball and they're getting that invoice for that increased amount, I don't know how the I don't know whether or not the initial fee includes coverage of the risk for the additional, like things like change orders. That's what I don't know. And if that was something that the contractor started to receive additional invoices for, we know that they're going to be sending out invoices as they learn about it. But I think you're pointing to a really important point, and that is like, when is the information going back to the surety company that their exposure has just increased by the amount of your change order?
Yeah, and then I'll let Ken ask his question. Then I'll have another question.
Well, so does the surety company, in other words, how does the surety company get paid? Through what mechanism is the bond paid? I know you can put the bond in the application, but how does he or she get paid?
Well, the surety company is getting paid like an insurance company would be by the policyholder, and the policyholder is the contractor. So the surety company is going to be sending the contractor a bill, and the contractor is going to turn around and say, I have this bill and it's bond expense, and that's eligible. So they submit it to Lauren, and Lauren processes it along with the other contractor costs. Is that what you're asking?
Got it. Yeah, it's up to the contractor to to submit that bill. Yeah, okay.
Okay. Another couple questions. I do think having some written guidance at this point of like, if it's 10%, even if you like, you have $100,000 extra in your budget, but your change order is 10%, you have to come ask the QUISP. I think that having some rules of thumb would be helpful. Because otherwise, Dean, I think you're going to keep getting texts from me while you're on vacation. And I don't love that for you. And then I also am wondering if there could be some template contract language that project managers could get for implementation projects, or actually for final design projects, if we're being asked to do bid solicitations during final design, to have for the bid documents and the contracts that explicitly lays this all out, so the contractor and the subgrantee can fully understand the process well in advance, and have that in the legal language. I think that would be helpful. And then relatedly, I think that this process feels pretty aligned with also the the site access easement or license, and how that's being held by the QUISP and not the project manager either. And just creating some clarity around roles of like, what is the role of the project manager in facilitating these documents versus the QUISP? Because I think, even at some point in this project with the back and forth of the site access easement, like I didn't even know what was going on during that. And that felt a little confusing.
Yeah, maybe we can put a side conversation about site access agreements for another day, because there's a lot there, and I think it does need its own discussion. But what I heard you talk about earlier, availability of template contracts, and before that you were talking about guidance on coming back to the QUISP for change orders of a certain size, and it would be, yeah, so some kind of framework. Like I said, it's I think we want to know when there are change orders. The communications part, I think, is going to remain. But if you're looking for some kind of approval or a weighing in, like we think that's a good change, that is something that I'm taking note of. But this is where I'm a little wary about, where is the line between the subgrantee managing the project and then the QUISP becoming a second manager?
I couldn't agree more, which is why I'm pressing the issue of, let's just have it clear what is quote unquote your jurisdiction versus ours, especially if the budget's already there. Like I get that if I need more money from you, that's one thing. But if I have the money in my task order, do I just need to tell you after the fact? Do I need to get permission beforehand? Do I just write an explanation in the quarterly invoice? Just trying to, because again, like theoretically, hopefully, we're going to have dozens of projects going at the same time. And we don't need you to explode. We really like you.
Okay. I think I had the concept down in the notes that I was just taking, and I see Megan.
Oh, yeah. Thanks, Lauren, for bringing this up. I think it's good to have clarity. I would just say maybe when it comes to larger change orders, we can align it up with the budget adjustment policy we already have for the QUIS. It's nice to have that flexibility as a project manager and a subgrantee to just coordinate directly, with the contractor and the engineering firm. you of course have your resident engineering team you can go to as well, to really, have that conversation about, hey, does this change order really make sense? What is the real need for it? So I like having that flexibility as a project manager to internally like have those conversations, and not make it too complicated. But I understand like if it's a large change order and it's over, say, if it's over 10%, then then it would be between conversation between Dean and like Peter, and myself potentially. So I understand if it's like, and then if it's over 20%, I mean, I'm just stating our current policy. If it's over 20%, then that's when it would go to the full basin council, for a budget adjustment request. So if we can line it up with that policy and still leave a lot of flexibility for the project manager to just kind of internally deal with change orders without having to get too many like cooks in the kitchen, I just appreciate that flexibility.
And then just one final comment on this. I will just continue to urge us to think about if these are BWIC meetings. I feel like they're more and more becoming project manager meetings and not council meetings. And so I think just trying to make sure that they're advertised as such of like, hey, if you're interested in applying to the quiz, these meetings are where we're going to flesh out like what project managers should know versus we're creating policy and voting and determining what projects are worth value. And I think like that distinction has just gotten really blurred over time because so many of us are also project managers and just trying to think through that in public participation policies.
Quick response or clarification on that for Lauren. I mean, raising a point that's really related to some training that I know that the QUISP are working on, or some of the QUISP are working on with Chris Rotler. We're in the process of identifying some topics that could be developed into courses or very short courses, and bonds were one of them. Contract management or project management, I think, was another one. And to some extent, I'll fess up that sharing some of this information and getting reactions from WIC members was in my own self-interest, is something that I could have applied to materials that might go into this training library. So I realized that in this particular discussion, it got into some nitty-gritties about projects, but where things are going is that there will be some kind of training library that all of those project managers would be able to access. So there's more to come on that. I did want to just, I mean, the packets included the copy of the form. For anybody that hadn't seen that, I'll just show it so people know what it is that we're talking about. But basically they're PDF files that you can fill out. And I had mentioned how we pre-fill who the developer is. So that shouldn't be a problem. And this is the language that we were provided with by our attorney that has those things in it that include the automatic adjustment. And this is where their signatures are. And this is the same thing for the performance bond. So that's what they look like if you hadn't seen them in the time that you had to review the meeting packet. But that's all I had. Thank you. And if you have other questions related to bonds, follow up, please send an email. And thank you, Lauren, for the specific comments that you gave about the process, which I have got here. And as far as site access agreements, I'll just say very quickly, another editorial. I think experience is going to show that we may want to give more thought to, in the design of projects, how the design is going to affect things like easement requirements, because frankly, the more parcels that are involved, the more complicated the easement process has become. And we are experiencing a lot of headaches with a project that has 6 or more property owners. And that means a lot of money for the legal part of it.
Thanks for having this training and opportunity to discuss, Dean. I really appreciate it.
Great. Any other questions on that topic before we move on, or just looking through, make sure there's no more hands? Okay, if not, why don't we move on to the update of our policy related to expedited project development?
Yeah, this is something of a housekeeping matter. I just wanted to be transparent about things. People will remember that about a year ago, or more than a year ago, July of 2024, excuse me, the Basin Council approved a policy. That policy essentially made it possible for the clean water service provider, excuse me, to create a program for awarding funds for project development. Basically, we were hearing at the time, it would be great to get more money out for project development. How can we do that? And we determined that one way we could do that was if there was an expedited application process, so that someone could make a simple application. They could come to the QUISP and say, I want to do project development. Here's the number. Or I want to do project development. Do you have a project number? And then we can write them an award. And when we did that, we were basically making the parameters 10 potential awardees. And I think it was based on the 9 pre-qualified organizations that we had at the time, plus the Regional Planning Commission. And we said $5,000 each. So we were imagining the program would be $50,000. We haven't had a lot of partner organizations ask for funds. So our view as the staff is that a new pre-qualified partner. So the list of pre-qualified partners is growing. I'm glad Dan's here, because Dan Winooski Natural Resources Conservation District submitted materials to become pre-qualified. And I just wanted to make it clear to the Basin Council that the way I'm looking at this is that it's really the number of pre-qualified partners times 5,000. That's the sum total of the program. I just don't want anybody to feel like if the clean water service provider treats Dan and his newly classified pre-qualified organization like those that were pre-qualified at the time, I just want to make sure that it's seen as the same. And if anybody felt like it would be worth adopting a motion to that effect, I think that would be great. But I just wanted to be transparent, because over time, the list of pre-qualified organizations is going to grow, which means theoretically, the total amount of project development funds that we could issue through this approach could grow as well. Anyway, Ken, I see your hand is up. You're muted.
Sorry. I think Cliff was working on a pre-qualified program for us, and I haven't heard anything. And I just wanted to know what the status was.
Yeah, Ken, we've selected Watershed to carry out the project development work, and I'll be meeting with Andres shortly to get that rolling.
Thank you.
Again, do you see Lauren?
Lauren, do you have a question?
I guess, Dean, I don't know if we were supposed to notice that that we have a signed contract for the Lamoille Basin. I don't know if that should have been on the agenda.
Say that again. I'm sorry.
The district got a expedited project development grant. I don't know if the council needed to be notified.
I'm trying to remember if the notification for expedited grants is not like the notification for amended agreements.
Okay.
I don't believe that was in the policy, although it may be something that we want to just make as a practice, is to keep people informed. And something else that thinking along the lines of is having a place on the QUISP website where we can have a live view of all the task awards. That's something that has some technical issues behind it, but that would be one way for people to know who has a signed contract or who has a signed task award, because we do have that in our smart sheet system.
And then as just as a second question, just thinking through project applications for this work, and the process of contracting with the QUISP, is it going to be practice moving, or like always, that the date of the contract will be retroactive to the WIC meeting where the project was approved? Or is it, or not?
Are you asking if it's going to always be the case so that you could anticipate like incurring expenses? Because we've made it a practice to date them as of the date of the approval, but that's I can't say for sure that that will always be the practice. I think that may or may not hold up because of the kind of risk that's associated with it. I can't say for sure that it will always be the case.
Okay. Is it possible to have a standard amount of time that, like, by 5 weeks after the WIC meeting, you will have a signed contract? I think it's just like it's been a little challenging to get a signed contract is what I'm trying to say. And just trying to nail down, like, because what we ended up having to do, we got something retroactive, so we then had to like go change all of how we had billed a bunch of time and how we had coded it, and that was just like a pain, is the second piece of the question.
Yeah, I'm noting the concern about how long it takes to get the contract signed on our end, and that's something I can pass along. But I do understand that sometimes the timing works out great. They submit their task award with their signature on it, and it goes into the queue, and it can turn around quickly sometimes, and then other times it doesn't. And some of that's a lot of it is the function of it is just it comes down to one person who signs it. And like I said, I can share the concern. But it would make I'm sure it would make you feel better if you knew always that the cost that incurred starting as the date of the WIC approval would be a feature, but I can't say that for sure.
Brad has a question.
No, I just thought I'd share how like VTrans grants go. So if you're going to get, like, say, a class 2 VTrans grant or a grants and aid or something like that, they'll let you know that you've received the grant. And then when you get the grant agreement, it's dated, well, in VTrans case, it's dated for the fiscal year, the state fiscal year. But however, you usually always get that grant agreement, maybe a couple months later, but it's predated that the award date was when you got basically when you got the notice. So.
Yeah, and that's kind of what we've been practicing with by using the date of the WIC action. but things, I don't know what kind of policy VTrans has in place to make that, but that's essentially what we've been doing. And getting some formal statement that says, yes, this will always be how it will be, is something I'm sure that I can ask about, because it would help people plan.
Or even like, again, if it's a super straightforward project, if you can get an email after the book meeting saying like, yes, you can start incurring costs now, or like, hey, we're not sure. Even like that level of clarity would be helpful, I think.
Yeah, so a notice to proceed is basically what you're looking for, Lauren, in writing.
Yeah, more notes.
And again, a lot of this is because districts are almost entirely grant driven. We don't have funds that aren't grant dependent to be developing projects. So that's why it's important for us.
Anything else on that topic, Dean? That you
No, sorry. Oh, well, I just was going to say, we do have a list of pre-qualified parties on the website, and like I said, it's growing. It's essentially, it has two phases. One is some party submits pre-qualification materials and they're reviewed, and then a recommendation is made, and a form gets filled out basically, and it gets signed off on, you're pre-qualified, but then that's followed up with a master agreement being written, and that's something that takes a little bit longer. And we have said in the past that when the first phase is done, someone can apply for an award. It's just that that award would not be inked until the master agreement is signed as well. So anyway, this is what this table is showing. And I see Lauren's hand up again.
Sorry, I just want to flag, I think Orleans and Caledonia should both be Orleans County and Caledonia County.
And on that table.
Yeah.
On that table. Okay.
And this is Ken. I think the town of Georgia should be on that list.
The town of Georgia, Ken, you and I can have a conversation about offline about that, and why there's a technical glitch, why it's not on that table. Ready to move on?
Yeah. So let's see, was the next topic talking about incorporating legal fees into the quiz awards in the future?
Excuse me. Yeah. Sorry about that. This is something that may produce some questions, I'm not sure. But as we were discussing a little bit earlier, for projects that require easements, which isn't all of them, but it's $200,000 threshold, there is an easement requirement, and experience is showing us that when the project has a single landowner and that landowner is a public entity, things aren't too complicated. They can move forward without a lot of legal time. But when there are multiple property owners with a project and they're private property owners, it can take considerably more time. And so what the director of the Regional Planning Commission had wanted me as staff to explore was a way for the Basin Council to be aware of the need for approval of legal expenses. And so what we've done this, like, to just recap, yes, we have to have site access easements. Basically, this is just recapping what I said. So we are adjusting the application form that people use to submit requests for funds from the Basin Council. And there's a notice on it that's going to look like this. So this is a section of the form, amount of funding requested. People are answering these questions, but we have added a note, and the note, whoops, the note is saying that budget materials prepared by the QUISP staff for the BWIC will also.
Sarah sent a message.
Oh, I'm sorry, was there a question?
No, it says
Oh.
enable.
I think somebody is unmuted. You hear a little background noise. Okay, that's better.
Okay, sorry. So what has been added is a note that says to someone who's making an application, when you submit your application to the QUISP to be brought to the BWIC, then the QUISP is going to include in the packet a note of some sort that said, oh, this is for an implementation project. We've sized it up in terms of the need for an easement, and we've therefore sized it up in terms of the complexity of the legal review. And then we're going to come to the BWIC with a number that we are saying, BWIC, when you are approving or acting on the request, we are also asking you to act on an additional amount that's for the legal expenses that the QUISP would incur for the site access easement. So that's what this note is about, and the practice going forward will include that. So the next application round, if you were submitting an application for a project that's going to require an easement, then when the materials are brought to the Basin Council, there's going to be an additional number that the QUISP is asking the BWIC for to cover the legal expenses. We're not asking the applicant to estimate the cost. We're telling the applicant that when the packet goes through at the same time that the request is being considered for the applicant's funds, then the QUISP is also going to be seeking approval for the legal expenses they would incur. Does that make sense?
Lauren, you have a question?
Two questions. I think that makes sense, Dean. Does that impact project cost effectiveness in any way? And can the project manager also bill for legal fees to have support similarly? And can that also not count towards project cost effectiveness?
So I think that, in theory, that it's going to mean some modest impact on cost effectiveness, but the kinds of projects that are going to trigger the need for a site access agreement are like, they're going to be more expensive projects anyway. So it's on a percentage basis, it's not going to be huge, but yeah, in theory, it would be something that lowers cost effectiveness, but that's the reality, is it's a project related expense. I just don't think, we can watch this as time goes by, and yeah, if there's some reason for a change, there can be revisited, but I just think the arithmetic is that it's going to affect cost effectiveness. As far as the second question, I think the answer is another question, and that is, well, what are the legal costs that the subgrantee is asking for about? What are they about? If they're not about the easement and the title work, and that's being covered by the QUISP request, then what would it be about?
I think that kind of feeds back into my question earlier about what is the role of the QUISP versus the project manager for the site access easements. And so this might be a moot point if we have more clarity on that. But I think just having more clarity on that would be helpful. Similarly, I don't know if this might be a separate issue, but like before QUISPs happened, you know, the project manager was signing O&M agreements, and the legal binding nature of those, I think, is still up for debate by DEC. And so I don't think I would ever sign an O&M again without a lawyer reviewing it first.
Yeah. So when you say you wouldn't sign an O&M agreement as a contractor, is that what you mean?
Yeah, so we, in the past, DEC had this one-page O&M of like, you're the responsible party, even if you're not the landowner. And it is unclear what that means when a project doesn't go well.
Okay. Yeah, separate issue because it's a separate form, and yeah, okay. Megan, I see your hand.
Yeah, just a couple follow-up questions to some of Lauren's questions there. So we used to, I know what form you're talking about, Lauren. We used to have the landowner sign the O&M agreement. We did not sign it as an RPC because we were not the ones actually maintaining the project in the end. We were not responsible. So it's usually the landowner that would sign the O&M maintenance agreement. But my other question, Dean, is so because these, incorporating legal fees into the budget will increase the overall budget cost, and we will have to factor that in, say, when we're applying for funds and we're looking at the phosphorus reduction figures. So are you thinking based on your internal experience, there's going to be like a standard amount or cap for legal fees that folks could budget, like put into their budget as a line item? Just so we can kind of like plan ahead, or are we just going to go directly to say the lawyers, maybe that we've used or the town has used and get an actual like quote from them?
I don't think it's going to be possible to have a single number that's always going to be the number that on average it covers the costs. I think it has to be as tailored to the project as is possible, which is why I said earlier that it's gonna take an assessment of the project itself, because I'll compare the two projects that we've been dealing with in Basin 6. One of them, public ownership, single parcel or single owner, and it was the first one that had an easement. So there was some groundbreaking, but it wasn't terribly complicated. And the second one, dramatically more complicated because there are so many parcels and some of them are private entities. So and so the difference in cost is thousands of dollars in difference. And when I said half an hour ago or whatever about, we may get to a point where in the process of designing a project, it would be good to think about what's the implication some design feature has on the need for easements. That seems a little bit like the tail wagging the dog, but in the latter project I mentioned, all of these parcels that are affected, well, there was one that had a very small impact, and the project could easily be tweaked to avoid that impact, and that meant one less landowner. And so I think those kinds of judgments may come up in the future if we know that easements are a thing. And that could also just reduce the cost. But the simple answer to your question is that I don't think a single number is the way to go, because some are always going to be higher and some are always going to be lower than that single number.
That makes sense. Thanks. Lauren, do you have a follow-up question?
I guess my question, Dean, is should those costs be happening during implementation, or should they be happening in final design? Again, if you're asking us if the documents or the draft documents are due in final design and you need a bid and all the bid work done in final design, shouldn't those actually be incurred in final design?
Well, so in a project that the QUIS funds the final design of, the deliverable requirement is the draft. So yes, a lot of it is happening in final design. And so what I said earlier about the implementation phase, yes, it would also come up in final design potentially. Although the costs, of the project are a little less clear when the application for the final design is made. So, but your message, I think, is a good one, and that is like getting a good head start makes sense. The project, another reason I think that the second project that I'm using as an example has been difficult is because the QUISP was not involved in the final design. It's only been involved in implementation. So some of the things that might have been done if the QUISP had been part of the funding of the final design just never happened. But what I'm going to say, Lauren, more directly to your question is that the title work isn't taking place in the process of drafting the draft easement. The draft easement isn't going to have the legal property description as exhibit A or whatever. So it's yeah, so I guess that's something to clarify for people. If you're doing a final design project and you're preparing the final, or you're preparing the draft easement, it's understood that you're not going to have a draft of the property description because the title work isn't being done at that point. Title work will be done when the project implementation is approved. Because otherwise it's just, we don't want to pay for all the title work when it's not even an implementation project yet.
Hello all, this is Erin. I've pulled over and I'm not able to raise my hand, so I'm just gonna speak. I just wanted to share that I think I would recommend that maybe the QUISP consider providing a range for legal fees. Vermont River Conservancy holds a master contract with DC Rivers program where, and our easements are different. They're river corridor and wetland easements. But we have to do the same sort of thing, title review, title update, insurance policy, and that sort of thing. And the state gives us a certain amount in our contract per project that says this is approximately how much it will cost. And not, I'd say, let's say 70% of the time, we use up all of that money and no more than, and we don't need any more than that to provide to the lawyer that we work with. There are some cases where we've had to say, oh, wow, this is like, we had to have our lawyer dive deep into clearing encumbrances or issues within the title. And so I think there's a way to have I don't know if it's a cap, Megan, like you were talking about, but a way to provide some, and maybe it's just guidance to say like, for if it's a site access easement, which is, I would think maybe less complicated, but I don't have experience with that, than a river corridor easement. There's like, okay, it's definitely gonna cost $5,000 for legal fees, and it could cost up to $10,000. Just like, I'm just adding my experience where I think you can get at it. At least provide some guidance, because I'm just listening to all this and I'm thinking about, yes, each project will have nuances to it, but if Lauren or Megan are having to go back and forth between the lawyer, sorry, I just lost my point there. I think that's going to take a lot of time on their end. And then that legal fee will increase. I don't know if I'm making much sense, but I do think like we should provide some guidance. The QUISP should provide some guidance to say, you know, this is approximately how much it costs. You can call 3 lawyers and get an estimate of how much it would cost to create a site access agreement and do the title work. And I bet you their numbers would be roughly the same, even though each project will be unique. So that's it.
Thank you, Laura, or thank you, Erin. I appreciate the feedback and based on your experience. Dean, did you have a follow-up in regard to Erin's comment?
Yeah, I think, Aaron, just very quickly, the Vermont Rivers Conservancy co-holds the easements, right?
Correct.
Yeah. So for everybody to understand, there's an important distinction between that process and what the QUIS process is, because Erin just described a situation where her organization becomes an owner. And we were talking about owners and the role of the bonds. The owner is the QUISP. And in a sense, in the easement case, the owner is the QUISP, not the subgrantee. So when I've been talking about these legal expenses, they're not the legal expenses of the subgrantee or the partner organization. They're the expenses of the QUISP, because we're the owner. And this is getting into like legal gobbledygook maybe, but the attorney, the money would be approved by the Basin Council for the QUISP to use to pay the QUISP attorney, because the QUISP attorney is representing the QUISP interest as the owner. We're not asking for funds to go to the partner organization to pay their lawyer, because their lawyer works for them, not for the QUISP. So I just wanted to make it clear that the reason why it's in this way is because the QUISP is the owner and it's the QUISP attorney. And yes, I think over time, you know, we'll develop an understanding of what the costs will usually pan out. And the site access agreement easements are different from conservation easements, and they are narrower, and knock on wood, they'll be simpler always than a conservation easement would be. But the reason why the setup was proposed as it is because the QUISP is the owner and the easement is held by the QUISP, and the attorney would be working for the QUISP. So your attorney can't work for the QUISP, or the town's attorney can't work for the QUISP.
But sorry, Dean, you're then saying that the Lauren or Megan, I never remember the terms, but a Lauren or a Megan, a project implementer, would have to build into their budget maybe I'm understanding everything just like way off base here, but the way I was hearing it is that they would have to build into their budget the process of the owner, the QUISP, having their lawyer create the site access agreement. And again, maybe this is too far into the weeds, but I'll just say the final thing I'll say about this is like I would suggest that the QUISP, you, Dean, and the others at the QUISP, if you're the owner, then and you have money that comes down from DEC, then you should work with the sub recipient, Lauren or Megan or others, to like use the money that you have and not punt it to the sub recipient to say, oh, here, you do this work for us. Because that's now what maybe again, I'm like misinterpreting what you're saying, but it sounds like you're asking them to do the work that you need to do because you are the owner.
No, that's not what we're asking.
Okay. I'm totally misunderstanding. Maybe it's because I'm driving.
So, thank you, Erin. So Dean, did you see Chris Rottler's note? I don't know.
No, I haven't seen any.
In the chat about the clean water funding policy, having some language in there that legal fees may not be eligible. This is see page 14 of the policy. Is Chris still with us?
Yeah, I'm sorry that you're now changing topics because that relates to pre-award fees. It's not related to your current discussion here.
Pre-award fees. Okay, thank you. Okay.
That was
So-
all that I had to share about that topic.
Oh, I just see another hand go up.
Sorry, still me. Can we just, like, Chris, are you saying that what an RPC is doing that before a signed contract, you aren't allowed to incur fees? Is that what you're saying?
Well, you can incur all the fees you want, but you can't bill them to clean water funds.
All right, Chris and Dean, discuss.
Let me look
Well,
at Chris's.
I'm just reading the funding policy. So, you know, I'm not the keeper of the funding policy. I'm just the reader, just like you are. And on page 14, it says that pre-award costs are not allowed. So, I mean, you can have pre-award costs, but my advice is you should wait for your agreement to be signed before you start work on the project, if you want to get reimbursed for all those expenses.
And so now you know why I was saying that I don't know that it will always be the case. And I think I use the term, you know, in the vein of pump priming in the early days of the QUISP.
Yeah, there's a lot going on with all this stuff. We have, like, this is a complicated program, right? So, like, I just, you know, it's a pain to remember to even look at the frickin' document where this might exist. But yeah, I had to look myself. I'm like, what's going on here? And so while you were having this conversation, I looked, and it's on page 14.
I guess, is there a definition of what award is? Because I think it could be argued that award happens during the book meeting when there's an approval by the council.
Yep, you could have that conclusion, but the language here, you should look at the document. It addresses that. Agreements must be fully executed, signed by both parties before incurring expenses.
Okay.
Yeah. I understand why you'd want to do that. I'm sorry that that's a little bit strict there.
And just remember, Lauren, we do have master agreements with any of the subgrantees who would be receiving a task award. So anyway, conversation maybe for another day, but I had reasons to say what I said before. It's good to get Chris's perspective because of where he is. And the last thing I would say is that the funding policy, it changes.
Yes. Oh, trust me, we are providing public comment on every piece.
Right. But I don't, you know, it doesn't change. It doesn't change quickly. But yes, I think it's good for Chris's perspective to be out there. Because I know that multiple QUISPs will send out authorizations to proceed essentially. So they're not following the letter of the funding policy either. So more to come on that.
Thank you. And again, I appreciate everyone. I know we're building the plane while we're building the plane while we're flying it, and it's just really uncomfortable. So, but I appreciate you all.
All right. Are we ready to move on to other, you know, you had some other general updates, Dean, such as the public comment period for DEC's revised cost rate methodology and the upcoming funding round for QUIST?
Yeah, there are a few different interesting things to talk about under this agenda item. It may take a little bit longer. I did pull together a few different slides just this morning, but so everybody knows, as a reminder, next funding round October 9. There has also been a proposal released by DEC to revise the funding policy. All of you should have received an email with that information yesterday. We're still trying to fill the vacant seat for the second watershed organization. We've had some conversation in the past about Peter Danforth's project in Hyde Park that experienced this significant loss. A lot of the planted trees died. What I can tell you, this item says request under review by the Clean Water Board. That's actually not accurate. We're basically hitting pause on that until next year because of some things that we learned about the procedures that are going to be used. So there's more to come on that. And I also think it's good that none of this is happening while Peter is away. And then I'm just also drawing attention to the fact that there was a set of policy proposals from DEC on several different topics that hopefully some of you commented on. But the one I want to zero in on is this second one, the proposal to revise the project cost method. I'm setting the stage with this table and these points. So there was an email yesterday, like I said. There's a document that hopefully you can find some time to read or scan. They're taking comments on that through October 17th. The comments go to Chris. And there's going to be a presentation a week before. It's going to be a Teams presentation. And so hopefully if you are interested in this topic, you can use the link that's in that email that went out yesterday. And my last bullet point is implications. Well, why is Dean talking about this, and what are the implications for me or for all of you? And so the implications are very significant. And this table shows that in the Basin 7, Lamoille Basin, we had 3 years of grants, 3 years of awards. Each award had a phosphorus amount, and it had a dollar amount. And I'm just going to zero in on the phosphorus amount because that's really where the implications are. By changing the cost rate methodology, the target for our basin is going to go down. And it's going to go down not just in the future awards, it's going to go down retroactively. So we're in the first year, the target was about 40 kilograms. Under the new cost rate methodology, that amount would drop to 16.5 kilograms. So looking over the 3 years of the grants that we already have, instead of having a 116 kilogram target to meet, basically, the target would be 48 kilograms. So it's a 58% reduction if the cost rate methodology is adopted as it's been proposed. And I think Chris can correct me if I'm wrong. There's a 30-day comment period that is in place, and then after that, the DEC would take some action, making it formal, and the contracts between DEC and the QUISP would reflect these updated numbers. So basically, same amount of money, or the money that we have, it's not being taken back, but the target associated with that would drop. So that's the first thing that I wanted to cover. And I don't know if there are any hands up. I'm going to stop. I see Lauren's hand.
Yeah, Lauren has her hand up.
Does this mean that the project cost effectiveness ratio is no longer kind of capped at $30,000?
So you mean the policy? So the QUISP policy for, so that's going to have to be revisited. We will revisit that, and we will revisit it after there's going to be time for more discussion. And some of that will be prompted perhaps by the slides that I was going to show next. But yes, the money that we have to work with per kilogram is going up because of the arithmetic. I see Ken's hand up.
Dean, could you put that table back up?
Oh yeah. Yeah.
So
Did you have a specific question about? Okay, sorry.
yeah, I'm puzzled to. I know we can comment to Chris on this, but I'm puzzled why the P reduction number is being reduced.
Would it be
Chris, do
helpful
you?
for me to jump in? I can give you a 2-second explanation. So there's a formula, and the cost rate methodology is a fancy name for that formula. And that formula is what's being revised. And you can look at the document that's connected to the public notice here that we have to go through as required by the law. But that formula is based on historical data that we had on what projects cost to implement. And the data, when we did this the first time around, ran through like 2016 through 2022, or 2020, sorry. So it was all pre-COVID data. And we've updated it with current data, and lo and behold, there's inflation. So projects have gone up in price. So the formula has changed. And so what it costs to implement a project has gone up. And that's what's being reflected here in this change.
So you're saying that the target P reduction is being reduced because we can't pay for the current P reduction?
I'm not sure I even understand your question. I'm saying that what we do, we have a formula to assign a target to a QUISP. So we have a budget of $7 million a year that we get from the legislature for clean water service providers. We've done this for 3 years. We're now entering year 4. It's been a little bit more some years, another $1 million in year 2 or whatever. But so $7 million. That $7 million gets translated into a target. And that translation is done with a formula. And that formula is what is being updated. It is based on historical cost information for what it costs by sector to implement a project. So it's expensive to do stormwater projects. And you look at what the traditional cost is per kilogram reduced. You look across forest sector and stream restoration sector and the ag sector, and the different sectors are weighted, and that's the formula. And what I'm telling you is the formula has changed because the historical cost information has changed. And so, yes, achieving the TMDL is more expensive. And so your target is going down because the amount of money isn't changing, but the what you get, what we expect you to get for P reduction is going down because projects are more expensive.
So why, Chris, why would you factor in any data before the program even started?
Well, the program started in 2022.
Right.
And we only had data from 2020. So that was the data that we had. And this is a complicated formula, and you can't update it every 3 months. We're updating it now, 3 years later, and we are able to provide more up-to-date data.
Chris, it just troubles me. For instance, in Georgia, Mill River has had a TMDL. It's a 303D river. It's had a TMDL that's never been implemented, and now you're saying, it's okay, we're gonna reduce the amount of P that's being put into St. Albans Bay because we don't, because the money doesn't go as far as it used to in 2020. It's just,
I'm not saying that the amount that the TMDL has changed. The TMDL, you still have your goals. There's still,
there's never been a TMDL for Mill River written.
well, that's not what we're talking about, Ken. We're talking
I
about
know,
what it costs to implement a project. If you want to comment on that,
obviously
you can. But we're talking about the formula and what it costs to implement projects. And the information is what it is. It costs what it costs to implement these projects.
Okay, I'll comment through the appropriate channels.
Welcome your comment.
Are we okay to go on, Megan?
Let me just make sure there's no other hands up. I think we're okay. And again, yes, you can comment to Chris via the public comment notice I went out up through October 17th, you said, Dean? I think it was the 17th.
Yes. So October 17th at 4 is the official deadline for getting those comments in.
Okay.
So if I can continue, and I did notice that Brad has dropped off. So in terms of quorum, we've lost Brad, but these are the numbers for the 3 years that are the subject of grants that have already been written, contracts that have already been written. The term of the Basin Council and the QUISP, I should say, is actually 5 years. So something that we've shared in the past is an estimate of, well, what would the number be for 5 years? What's the total amount of money that we have to work with if we are looking at project costs now, but revenues coming in the future? And so under the old or current system, it's about 200 kilograms, 195 kilograms over the 5 years. And over with the revised, it would be 81, and the amount of money is still going to be the same. So the money doesn't go as far. And yes, the targets are a function of the amount of money that is available. Some things that I wanted to touch on as well, though, like where does this go? I mentioned implications. I wanted, because Megan, you had said, like, where do things stand with our projects? I know this is a very busy slide. I'm going to draw people's attention to some things. So this is a listing of projects in the Lamoille Basin. I believe it's as updated as we've got it. And this is got the columns for the projects, their phase, their estimated annual phosphorus reduction, and what the amount of money that the QUISP and the BWIC have said, you know, here's our commitment so far. But then we've also got this issue of, well, what would it cost to get these projects done? And someone else might come riding in with a lot of other money that doesn't take away phosphorus credits. But if they didn't, what's the total cost? I just wanted people to know that it's a lot of money. $9+ million for all of the projects that have been through the BWIC and the QUISP in some way. Now, I will say quickly, there are some projects that I know, for example, the Bellows Falls East, that actually cost a little less than was awarded. So this $45,000 figure is not the $75,000 that we originally came up with, but the implementation cost is very high, and so I don't think that that's one that we will necessarily go forward. But my message here is that we have a lot of projects that have had some contact with the QUISP and the BWIC, and they would cost a lot to implement fully. Now, it's a lot of phosphorus, which is good, but now we'll see that it's way more phosphorus than is required to be reduced. So what are we going to do? And this is just really to get people thinking. I don't think we have much time for conversation, but I wanted folks to realize that when I started puzzling over these numbers, my mind went in a few different directions. And one was, and I realized this is another funky table, but I'm going to try to break it down. You don't see the list of projects off on the left. Hopefully you can see my cursor. But basically there are a couple of categories, and the categories begin in the gray bar. So the first gray bar has total project cost, big impact. So I just wanted to get some sense of, well, if we focused on projects that had massive amounts of phosphorus reduction, how much would they cost to implement? And what's the total phosphorus reduction? Well, if we focused on two projects that for now have phosphorus numbers that are really big, $2.2 million in theory could be spent and would get 228 kilograms of phosphorus. That's an interesting concept, but I know it's not the only concept. So another one was to say, okay, let's look at the more modest projects. So this is the white bars with the line in between. So I picked projects that had basically between 10 and, well, it works out to be 10 and 25 kilograms of phosphorus. And what's the phosphorus total for those modest cost projects? And how much phosphorus is it? Well, 76 kilograms of phosphorus for almost $7 million. So, gee, thinking about a strategy that's looking at modest cost projects, oh, that's maybe not going to be an easy thing to do. And so then I looked at this second gray bar where I looked at the small impact projects, so the ones that were essentially less than 10 kilograms. What happens with those? Well, it's a $500,000 implementation cost, but it's only 20 kilograms of phosphorus reduction. And my point in illustrating this is that this isn't simple to put the pieces of the puzzle together. It's helpful, I think, to get some understanding of the relationships between cost and effectiveness. So where does that really leave us? So when I did a simple calculation of this second white area total, and I called it rounded project costs because I just didn't want to deal with too many decimal places and things like that. But if we take the total rounded costs for implementation and I ranked them, so this is a ranking of cost effectiveness basically for these projects that are not shown on the screen. You can organize them from 1 to 14. And in a lot of other basins, there's a lot of conversation about and in ours too, there's a lot of conversation about cost effectiveness, dollars per kilogram. And I see Lauren's hand is up, but I'm just gonna take that in just a second. But I wanted to then show that it's possible to look at, well, what if we funded the top 5 most cost-effective projects and their complete costs? What would happen? What would happen if we would take the next 6 and what would happen? And so these are some approaches that with a lower target to reach and with these really dramatic total implementation costs and the great uncertainty there is about who's going to pick them up, that we may need to start thinking about more as a basin council. So because if we look at the top 5, okay, I'm just trying to see here. Sorry, things flashing on my screen. Yep, sorry about that. Taking an approach where we focused on the best performing projects may be where we would find ourselves going. So we can take the top, I think, 7 projects, and we can have 280 kilograms of phosphorus reduction for about $2.6 million. These are, again, just meant for reaction today. We will be talking about these more as we get into the next application review phase, because we're going to have to start, I think, sharpening our pencil. So although the dollars per kilograms go up, and the targets are going down, we do need to think about getting projects in the ground that are going to move us toward the targets, because right now, the only projects that we've had in the ground that have resulted in credit have had that credit suspended basically because of project loss. And the reason I've gone back to this this implementation project, this is the Hyde Park buffer planting where it was 8 kilograms, and we can no longer count those kilograms because the verification found that the project isn't performing the way that it was supposed to. I'm going to stop now and see what question Lauren has.
More of a statement. I think kind of to your point that about Peter's project too, like the phosphorus calculation guidance is changing, and it's a lie at concept design phase or pre-concept design phase. And I just want to name that it's just a lie, as is the budget. And so I appreciate that, Dean, you have a responsibility, but like anything prior to implementation, that number is a lie. And I'm just going to keep that out there.
Right.
Sorry. And I meant to actually add to that. It would be really, 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 really helpful if someone, DEC, NRPC, had one person who was making sure that the P reductions for each project were being done right and in alignment with the DEC policy the whole time. Because I think engineers are confused, project managers are confused, DEC within itself doesn't agree with what the rules are, and it's a challenge.
Yeah, and my response very quickly is that what I really want to do is encourage people. We have this money. We need to get projects in the ground. I want to start. I want to see something more than the less than 1 kilogram phosphorus reduction of Peter's fishing access or boat access in Elmore. In the wind column. I mean, we have all of this potential, and I appreciate those numbers are funny numbers, but we got to get some projects in the ground because we don't have real P numbers. I mean, I appreciate none of them are real, but.
And Dean, again, I love you. I want to get projects in the ground too. And the process that has been laid out, requiring concept design, requiring final design, and the time that takes, and trying to answer the questions from all the regulators 4 times in that process, and having limited regulator response and availability from DEC is a large part as to why we're not getting projects in the ground. So
is Chris still on?
No. Sorry, Chris.
Yeah, can you say that again, Lauren?
I think the reason why we're not getting projects in the ground is the rigidity of the steps required to get to implementation and the lack of response from regulators and the multiple check-ins with regulators to try to get a response.
Yes.
Has been challenging.
Yes.
And that is part of the reason why we're not getting projects done. And
yes.
It's not news to anybody, but I'm just going to keep saying it. Thanks, Chris.
You're correct, Lauren. I agree.
To the point where I would be more than happy to have fewer projects that I'm leading to hire somebody else at DEC. If that is a way that this money can be reallocated or something, like I'd be.
Hey, that's cool. Yeah. I actually have identified like 17 gaps that we would love to fill. And one idea I had was, can we take 100 grand from the clean water budget for QUISP and use it to create an FTE? And that's actually not allowed. That money cannot be used for staff. The funding for DEC would have to come through. It's a different budget, so it's apples and oranges.
I'd be happy to submit a public comment on whatever budget that is as well, if that would be helpful.
I have no advocacy for you to say what you should submit public comments on. It's not my role, but I want to let you know, I hear you. There are some barriers, and the barriers that you've identified are real. And yeah, it is what it is. On the flip side of that, I just want to, I'm not trying to sugarcoat anything, but like, there is frustration. I'm acknowledging it, but you all are doing a really great job, and I thank you for the work you are doing. So I just want to just reflect back at you. I appreciate the good things you're doing despite the challenges, for what it's worth. It's not easy, and you've got hurdles. So thank you for everything you're doing.
Thank you, Chris. Appreciate that. Dean, were there any other updates?
No updates, but the under this concluding section, and I realize we're over time, I wanted to really highlight that there's the need for the Basin Council because of this annual conflict with the Thanksgiving holiday being the fourth Thursday. I know that, so we have to choose another date. I don't think that the day after Thanksgiving is going to appeal to anybody, but I just wanted to throw it out there. We've met 1 week later in years past, so that would mean December 4. We could meet at the same time, 9 to 11, or possibly do another time. We could also consider December 5th. So sometimes people's Fridays are a little bit more open. In my schedule, though, the only time that would be available. But I would really love to get some indication from the group which of the dates is preferred, and I can get that on the schedule.
Are you looking for indication now?
Yeah,
or...
I would love an indication now. If there's a preference that can be expressed, I would love to know it so that it can be acted on.
Okay, well, let me just give folks a second to check their schedules then. Real quick.
Ken's hands up.
Oh yeah, Ken, do you have a question?
The fourth is fine on my end.
Okay. Want to vote for December 4th?
And Ken, that would be 9 to 11, the regular time, but just 1 week delayed.
Yeah, the regular time is what you said on the 4th, and then the 5th is different.
Okay. Well, if there are no objections at this point for the 4th, then I would love to pencil that in, and then I can send something out more formal, and we can see whether or not there are issues with the turnout. But let's look at the 4th. So thank you very much for that. And that's the end of my need to blab in front of you. So any motion to adjourn would be in order.
I so move. This is Lauren.
All right. Motion to adjourn from Lauren. Do we have a second?
I can second it, Ken Mink.
All right. Second from Ken Mink to adjourn. Any further discussion before we adjourn? No? All right. All in favor, say aye.
Aye.
Any opposed? Oh. All right.
Thank you all.
Thank you so much.
Take care.
Enjoy the afternoon.
Thanks, Dean.
Thank you for having me. See you.